from the writ. Okay, so you have 14 days. So what about judgment in default of defense? Which order number is it? 19. Okay, so you remember all that already? Okay, yep. So failing to file AS. What is AS? Acknowledgement of service of writ of summons, right? I heard the answer. So remember, this is like a short name of it. Acknowledgement of service of writ of summons, because that's what you are acknowledging. The defendant is acknowledging, yes, I received the writ that you served me. This service is the plaintiff's service of the writ on the defendant. Okay, so they're saying, yes, I received the writ. I acknowledge you served the writ on me, and I will tell you now that I intend to defend the action or not, right? Next, we drop to here. So only if they didn't comply, didn't file the AS, you straight away go for order 13. Okay? If they file the AS but fail to file the defense, then judgment in default of defense under order 19. They have 28 days from from the statement of claim, right? Now, this is what we want you to remember for exam purposes. The bonus additional information is that sometimes, in reality, sometimes even if if they didn't file the AS, you have to wait for order 19. But that's more complicated. For example, because of some specific remedies that you're after, it doesn't fall under order 13. Okay, but for your exam purposes, just remember, no AS, order 13, no defense, order 19. That's what we want you to. You will find that if you, in my last lot of civil procedure students, I think one of them asked me, I think something along inter partes summons. Now, what we're teaching you is superficial at the moment. We just want you to remember the fundamental concepts and the basic rules. As you go, if you actually dive into, not the white book, but just the rules of High Court or rules of District Court, it actually gets much more complicated than we teach you. You would assume too as well, right? Because there's like 100 odd orders in rules of High Court, right? But just remember the basic concepts, you'll be fine. Okay, so we've gone through orders. Okay, let's say the defendant received the writ, doesn't want to defend. What can they do? Just admit the liability. On the AS, they would tick, no, I'm not contesting the claim. They can either fill in, if it's a monetary claim, they can fill in Form 16 or 16C, depending on whether it's liquidated or not liquidated, right? So good. Then it will have the effect of stay of execution. Okay, now last time we have done that, right? We've done this, right, last time? We've gone through here? Should be, right? Application by summons supported by affirmation. In actual fact, it's the same procedure for order 13 and order 19, right? Except that it's under a different order number. Okay, order 13, judgment in default of AS. We have application by summons supported by affirmation. Okay, and depending whether it's liquidated or unliquidated, right? If it's liquidated, quantum does not have to be assessed and determined by the court. And therefore, the plaintiff can straight away apply for final judgment, right? If it's a $3 million loan at 10% interest per annum, it's ascertainable, right? Under the loan agreement, remember liquidated just means ascertainable, right? It doesn't have to be a fixed amount, as long as it can be calculated. Okay, if it's unliquidated amount, for example, because it's a personal injuries claim, the plaintiff says, yes, my loss and suffering should amount to compensation of 3 million. That's not agreed, right? So the court has to assess that. So in which case, you would have final judgment on liability, but the quantum will need to be assessed. Judgment in default of defense. Okay, so if it specifically endorsed writ, meaning the SOC is already with the writ. Yes, remember the S with S. Okay, so SOC endorsed on the writ. So 28 days after the last day permitting for filing the AS, which means what? Writ served plus 14 days. That would be the last day, expiry date for filing the AS, right? Do we agree first? Right? Then count 28 days from that time limit for AS. Are we on the same page? Do you understand? Right? Most of the time we don't have exam questions asking you to calculate the date, but for your general knowledge you should understand. Let's say is a specifically okay, excuse my writing, it's horrible. So if you have writ okay, from here to here, how many days have you got? Writ and AS. Like last day for AS. How many days again? 14, right? So, I should have waited. So it's 14 days. I'll just write 14 days here. And then 28 days after that limit. This is writ with SOC, right? Right, so from here to here, and then you have another 28. So altogether you have 42 from the writ. Again, we rarely ask you to calculate, but just for your knowledge, you should know. Okay, okay, are we okay with that? Okay, just put it here then. And if it's generally endorsed, so we don't have SOC, not SOC. You just have to count from SOC. Okay? That's simple. Just count from SOC. That's what it's saying. So we all good? If SOC and endorsed already, count 14 days for the AS. Last day permitted for filing the AS, which is 14 days, plus 28 days. Okay, after the expiry date. Okay, don't confuse that with the actual day filed. Are we all good here? Yes? Okay, here just count for general endorsed writ because we don't know when, right? So just 28 days after the SOC. Order 19, judgment in default of defense, same deal. Exactly the same, right? Summons, affirmation. For liquidated amount, again, plaintiff can seek or ask for, apply for final judgment. For unliquidated amount, final judgment on liability. Interlocutory on quantum, which is to be assessed by the court. Exactly the same. Okay, so you're actually remembering two orders for the same thing. Okay, we're talking about for order 19. Okay, we're still on order 19. If the defendant has actually filed the AS, you must give a notice of intention to enter judgment before entering judgment. Okay, remember I said the last tap on the shoulder as a last time warning. Hey, I noticed you filed your AS indicating you wish to defend, but you haven't done your job and you haven't filed the defense. This is my last tap on your shoulder to warn you that I'm going to enter judgment against you. Are we good? Yes? Is that a yes or no? Are you okay? Do you understand? Right? Okay? Last minute warning, yes. Okay, so now setting aside or vary judgments in default upon an application. Okay, that should be the end. An application by the defendant on such terms as it sees fit. Now the court has a very wide discretion. Remember we said, well, it's a final judgment and can be enforced, right? If the plaintiff gets a default judgment from the court, right, whether it's Order 13, Order 19, it's like a final judgment, capable of being enforced, just like any other judgment. And the case would conclude. Remember, this is one of the mechanisms you can shortcut, 腰斬咗, right? You shortcut the whole process. However, once the defendant found out who was Hilda against Alice, was it? I think last time, right? Okay, what's your name? I'm sorry, your hairstyle seems a bit different today. Okay, so we had Alice last time. So I remember it was Alice and Hilda, right? So now Hilda found out, oops, that's a default judgment against me. But I think last time we said perhaps either she was slack and just didn't react to the claim, or she didn't get the writ and the SOC. Right? So if we want to set aside judgment in default, depending on whether it's in default of AS or in default of defense. So corresponding rule, Order 13, Rule 9, Order 19, Rule 9. Okay, we said that is a balance between making the parties comply with the rules and not doing injustice. I remember you told me last time, right, when I asked you again, I'm going to ask you again the question. If Alice did not serve at the proper address of Hilda, it becomes an regular or irregular judgment. Irregular judgment, right? The name suggests that something wasn't done properly. So something wasn't done properly, as opposed to if Alice did everything right, then it would be a regular judgment. So which one is it more difficult to set aside?
Irregular.
Regular, right? Because Alice done nothing wrong. She's totally entitled. Okay, so if it's, as you said, let's look at irregular first, because it's easier, right? Irregular judgments may arise where the plaintiff has failed to comply with some relevant procedural rules. I'm going to move that mouse off. Okay, some procedural rules have not been complied with. Serving at the wrong address. Defendant was not at the jurisdiction at time of service. Right? This one tends to be very common. Right? Either the wrong address, it's not the last known address. Okay, this too tends to be very, very common. Now, most of the time, the firm is not going to calculate the wrong time limit. Okay, if you've got legal representation. Okay. Remember when you look at the service rules, if you use, what are the two main modes of service again? Personal service, yes. That's the most preferred way because you get the person right in front of you. And the other one? Postal service. Postal service, then, this would be very important because you didn't serve on the person, you don't know whether he was in jurisdiction. Right? So most of the time this would occur, this too would occur because it's postal. Okay, either by registered post, whether it's etc. Okay? Yeah, in fact, I'm doing one of this. The defendant has actually been detained in mainland PRC, and he was never in the jurisdiction. So that's the basis that we're going to challenge on. Okay, and I'm going to, you can show that by what? What evidence can you show? Immigration records, right? Or what we call, the proper name is Statement of Travel Records, but along that line, okay? Whether it's by passport or by immigration department records. Okay, it's actually very easy. There's an online form, you can fill it in, etc. Okay, but you've got to be the person yourself. Otherwise, you have to get a court order. Okay. For example, if a wife is trying to get the husband's travel records, need a court order because he's not the what do you call it? The person himself. Okay. Improper mode of service. Judgment entered against a minor. Judgment obtained fraudulently. How can you have fraudulent? How can you have fraudulent judgment? Well, perhaps you lied to the court for something. Well, normally if you serve at the wrong address, it'll probably be number one. But for that, the basis of your claim might probably be some sort of fabricated. If you have a, let's say, someone who had done the, would be, let me think of an example. If the basis of claim is actually made up, and then the plaintiff subsequently tried to cover it up by improper service, that can happen, right? Because there's no one standing up to argue, right? Okay, that doesn't occur that often, but if the defendant never got the writ, then there is that chance, right? Because he has no way, the defendant has no way to know that there's such a claim. And if the basis is not entirely correct, then there is the problem. How do you apply to set aside? Okay, notice the word we use is set aside. Not cancel, not appeal, not overrule. Use the proper wording. Now I'm just marking the other lot's assignment, and because I have to give my apologies to you because I've just set the assignment question. Just very recently. So Katrina is going to post to you, as in post it on the, or notify you by mail or email. Okay, so my apologies. Okay, I'm sure she will give you the due time that you should have. I'm going to make sure on that. Okay, because I've just, did everybody get that? I've just set the assignment question. Okay, so you will be given sufficient time because it wasn't my fault. I think I'm a few days late. Okay, so, but just to, I'm going to, because I'm going to let you have the chance to read the question first before I go over it with you. Okay, that's why I'm not going to go over it tonight, but probably another evening or another class. Of course, I'm not going to give you the answer, but I'm going to discuss with you what I expect. Okay, that's fair, right? I'm not going to give answers in class, right? But one of the pitfalls in doing assignments is not using precise terminology. For example, if it's setting aside an irregular judgment, don't say cancel a judgment. Okay, use the proper wording. Okay, that's the legal jargon. Okay. So application to set aside an irregular judgment in default is before a master by summons and affirmation. That's for both Order 13 and Order 19 default judgments. Okay, same way. Irregular judgment will be set aside as of right. Okay, you should get used to the terminology. If you ask me, why do they use as of right? Why can't they just say automatically entitled? Don't ask me, I can't answer that question. It's just a terminology, so you have to get used to it. So, as of right, just equals entitled or automatic? Or okay, that's all it means. As of right just means it's automatic or entitled. You can expect it. It's within what you should expect. But when you write your answers, you're going to use as of right, okay? It doesn't like being dropped. Just like when you see the word, got another question? Save. Now that doesn't mean savings in the bank. It means accept. Okay, you know what I mean by accept that. Okay, that just means save as a criteria. So accept that. That's exactly what it means. Okay, get used to it. Okay, unfortunately we can't change it the other way to make it more layman, so we just have to get accustomed. An irregular judgment will be set aside as of right without looking into the merits of the defense. Because remember, Alice didn't comply with the rules. So the court is saying, oh, the defendant didn't ever get the writ or didn't ever get the SOC. So it's Alice's fault. So we're going to let Hilda, where's Hilda tonight? Oops, missing. Well, we're going to let Hilda, give Hilda her chance to file the defense or AS, whatever she's supposed to file. Right? She's never been given the chance. Okay, so set aside as automatically. Okay, automatically. So not much question asked, and we're not going to look at the strength of the plaintiff's case and the defense case yet. But the court may attach conditions for setting aside. Now you're going to say, hang on, if it's automatic, why do we need conditions? When we say conditions, we normally mean against the defendant. In some cases, courts are more proactive nowadays. Okay? It used to be that no questions asked, no conditions. Nowadays, the court sometimes, they would want to hear a little bit about the defense arguments. Very preliminary. But if there's nothing in the defense case at all sustainable, the court may still set aside the judgment but attach certain conditions. When you hear, well, certain conditions, what conditions? Normally it's payment into court. Okay? Why? Well, we hear a lot of payment into court. Why payment into court? Like a security. Right? Like a security. Okay, you want to defend? Okay. You want to defend? I'll let you have your day in court. I'll give you your chance to defend. But to me, you don't sound like you have much argument. So just to be sure, I'm going to get you, the defendant, to put some money into court. Not to the plaintiff, right? Because we don't give money to the plaintiff yet. They haven't won the case. Correct? Alice hasn't shown her case yet. Nothing proven, no evidence, nothing. Right? Only the pleadings at this stage. So we're not going to give your money to the plaintiff, Alice, yet, but we're going to hold it into court to make sure that going onwards, everybody is going to be good and comply with the rules. Normally, if it's an irregular judgment being set aside, normally the court doesn't attach conditions, but the court has the discretion to. And that's what you have to understand, that's all. Normally they wouldn't, okay, because it has been an irregular judgment. Regular judgments. Well, if it's regular judgments, it's totally, entirely the fault of the defendant, right? The defendant just hasn't put up her act. Okay, judgments obtained where the plaintiff has fully complied with all relevant procedural rules, but the defendant has still failed to return the acknowledgement of service or filed a defense within the time limit. Again, application to set aside the regular judgment in default is still before master by summons and affirmation. Pretty identical, right? You've been hearing that a lot. Before master, by summons, in affirmation, in chambers. Right? It's going to be heard in chambers as well. Now, the defendant, you've been naughty, you did not file your stuff. Give me an explanation before I will consider, because the court has discretion, right? Before the court will consider whether to give you leave. Why leave? Because they've gone beyond the time limit. So unless the court gives them permission, which that's another word, right? Leave, now equals permission, right? So they need permission from the court. In civil litigation, you see, or if you're in a civil litigation process, you hear a lot of time extensions, because every time you breach a time limit, you can't do that thing anymore unless the court gives you leave. Okay, whether it's filing a witness statement, filing an AS, filing anything, or even if you've gone beyond the time limit to exchange witness statements, everything you need leave of the court to extend the timeline. Okay, so if the court doesn't give them leave, and they don't have, they can't set aside the judgment in default. Let's pick on somebody else. Simon, yes. Simon, you have not filed the defense. So actually, you want two things from the court. You want the regular judgment to be set aside, plus you need leave to file the defense. There's actually two things. If you file a summons, that's the two things you put on the summons. Okay, so Simon, you've been slack, sitting there doing nothing. You need to give the court an explanation why you did not file the defense within the prescribed time. And because it is a regular judgment with Alice doing nothing wrong, you have to show me that your defense has merit. Okay? Slightly stronger than an arguable defense. So just remember the word defense has merit, because arguable defense is something we're going to use for summary judgment and other application altogether. So just focus on the defense has to have merit. Okay, so to persuade the court, the test is whether the defense has a real prospect of success. Now, further on exam skills and assignment skills, one thing I have to remind in marking the assignment, I keep on giving a lot of comments, do not cite chunks from judgments, textbooks, course manuals, etc. But for key phrases like this, yes, you have to use them, right? The test of real prospect of success is just that. Do not reinvent the terminology. But don't give me from this case, yes, I think this was a tenant and landlord, I think. But anyway, don't give me all the background facts of the case unless it's really identical. I just want the principles. Okay? Do not cite chunks and lines. You're using up your word limit, doesn't give you much marks, right? And you do not show me that you have understood the principles, or you can't paraphrase. Okay? The court may attach conditions for setting aside, and for setting aside regular judgments, they often do, the court often do. Okay, because Simon's been the naughty one. Mostly those conditions involve payment into court. It's just a matter of how much. Because the court is not going to make you right? What kind of punishment can the court give you that pinches money, right? So, and it's more universal and applicable, and it gives puts you on your foot to be more alert. Okay, payment into court of all or a portion of the amount of the plaintiff's claim. But the conditions imposed should be ones that the defendant can reasonably comply with. Now, while this is the principles that you have to remember, in practice, well, on one side, the court is gonna, you've been naughty, so pay some money into court to make sure you are on your feet all the time. You'll be more careful next time. On the other hand, if Simon's saying, I am very poor, if you are asking me to put money into court, I might as well just abandon it. I can't carry through this litigation anymore. That's the other extreme, that the court is reluctant to be oppressive to push Simon out of the litigation just because he can't pay the comply with conditions of payment into court. So the court will take the extremes into account, okay, in practice. Because it would be injustice, right? Okay, so any questions about setting aside judgments in default? Okay? Now we talked about Form 16, Form 16A, C? Was it C or A? Oh my goodness. 16C, here we are, right here. So Rules of High Court Order 13A is a mechanism for if the defendant doesn't want to contest the claim. The defendant can admit the claim. Now, assuming it only involves money, then defendant can use those Form 16C or Form 16 to propose payment terms, just as what we've looked at before. Okay, because remember when the writ was served, it was served whether with general endorsement or statement of claim together with AS and one of these forms. Only one, right? Because it can't be both liquidated and unliquidated. What if you say, well, what if there are two components? One is liquidated, one is unliquidated. Well, it will be unliquidated in total, right? So you would still attach 16C. Okay, so defendant can admit whole or part of the claim. Admission is binding. You can't turn around and say, oops, I've changed my mind. Not permitted. Now the defendant would have or fill in on the Form 16 or 16C details of his financial position. We looked at that last time, right? In your course manual, there's a sample. Did we look at that? Yes? No, we didn't. Okay, we're going to look at that after this slides. Okay, so in that form, they can propose, yes, I will pay instead of $500,000, which is 500,000. I'm going to pay 100,000 every 2 months, and I'm going to pay it off in 10 months, something like that, right? Can offer payment terms. Okay. The defendant returned the AS filling in Part 3. So admission form to be filed by the defendant and served on the plaintiff, the other side, within 28 days after time limit for AS. So 14 plus 28 again. And upon receiving that Form 16 or Form 16C, the plaintiff can then apply for judgment. Now, if plaintiff does nothing, because that form is filed into court as well, right? So the court knows. If the plaintiff does not apply for judgment, then the case will be frozen or paused until he does. Can you see? Because, well, it's finalized, right? If the defendant admits liability and is proposing payment terms, it's just a matter of settling the terms, right? If they can't be agreed, then the court will make a decision. Okay, so that's what point number 7 is saying. So in that form, the defendant is stating his proposals, payment time, by installments, terms, lump sum, etc. he can accept the proposals or he can reject and make his own proposals. And again, as I said, if the parties cannot agree, then the court will just decide. Okay. The court can even decide without a hearing. But if the parties are unhappy about that decision, they can apply, either party. Okay, one of the parties or both of the parties can apply for the court to make a redetermination. While, let's say, I said Simon's offered 10 months to pay the 500 or $500,000, right? $500,000 in 10 months. During those 10 months, the stay of execution of the judgment will be stayed. Okay, he's got to make his payments. If he doesn't, Alice can continue to enforce the remaining amount. Of course, not the full amount. You have to take into account what he has paid, right? So I think that's the. Oops, we still have. Okay, where is the manual? Form 16 is on 100. That's a form 16, which is very tiny. Do you have your manual? You have your manual, right? So on form 16, Paul Smith and Dan Black again. Notice we always like P and D, right? Okay, explanatory notes, that's only explaining how. That's on page 101. How much of the claim do you admit? You can admit part of the claim or the whole amount. Your personal details. Here, remember the purpose is to state all your financial details and status, plus making proposals, okay, payment proposals. So that's why you see personal details, dependents, if you have children to feed, right? Your income source, bank accounts and savings. Do you own your own property or rent, etc.? Income, other assets or income, expenses and liabilities, right? It breaks down to really everyday expenses, living expenses. Liabilities, name where you work for. Okay, so assets, offer of payment. I can pay the amount admitted on such a date, or I can pay by weekly, monthly installments of 100,000 or 10,000, whatever is the case. If you cannot pay immediately, please give brief reasons below. Simon's going to say, I don't have enough money. Okay, I don't have enough cash right now. I only get so much a month, etc. Okay, declaration. Declaration that the above information are true. Okay, so that's what it's doing. It's pretty simple to fill in. Okay, now. Reflection activity 1. Why should the plaintiff be allowed to apply for default judgment if the plaintiff fails to return the acknowledgement of service within the prescribed period? Why do you think such strict mechanism is in place? What is the purpose? Remember, everything there is for a purpose. It's not that the court is too relaxed and wants some mechanisms in place. Why do we have those? Well, first of all, why do we have timelines and why do we have mechanisms almost to punish, right? To deprive the other party the chance to fight the case. To make sure parties
don't waste time.
Comply with timelines, right? Okay, comply with timelines or else have consequence. That's the AS. And also, well, in particular the AS, we want to know, are you going to fight or not? Right? That's the purpose of the AS, right? What's an irregular judgment? I think it's pretty... If the plaintiff has done everything in obtaining the judgment, default judgment, did the plaintiff comply with the rules? So irregular judgment is where, yes or no, comply or not comply? Not complied, okay, irregular. So number 3, how can a defendant set aside a default judgment? Is there any, okay, first question first here. How can a defendant set aside a default judgment? I think, 背咗成三啦，係嘛? Application by summons and affirmation, standard package, right? Almost everything. Mostly, remember I told you, mostly inter partes applications, mostly summons and affirmation. Only sometimes you don't need the affirmation. In most occasions you do. Okay, so you just watch out the ones that doesn't have. Or if you don't need summons, one way or another, something is missing. Mostly, it's twin package, right? Summons and affirmation before a master in chambers. Okay, standard deal. So yes, that's how you do it. So remember, it's both Order 13 Rule 9 and Order 19 Rule 9. That's to set aside. That's application to set aside. Is there any particular time period in which an application can be made by a defendant? Any time? Did you hear me say any time limit? As quickly as possible. That's all. Right? When you find out that a judgment has been entered against you, Simon, you better act quickly. Whether it's regular or irregular. The longer you wait, the harder it is to persuade the court, right? Or explain the time delay. Even if it had been an irregular judgment. Well, after you are aware of it, if you wait for 2 months or 3 months, then you're not so much in the right anymore, right? You've lost your merit of your arguments. Okay, so I guess ASAP. No specific time limit, but most people would do it as quickly as possible. Is it justifiable to attach conditions for setting aside a regular default judgment? Set aside a regular default judgment. Regular default judgment, Alice, plaintiff, nothing wrong. Defendant's fault, so you think it's justifiable? Right? This is attach conditions to who? To Simon. Okay, to the defendant. Okay, so fair enough, right? If it's Valis did everything right, Simon's just been late, right? It's just, I guess, fair. Wow, long question. A defendant applied to the court to set aside on order 13 default judgment. So against default judgment in default of AS. Okay, entered against him 6 months ago. Goodness. He had changed his residential addresses in Hong Kong from time to time, and just in the past year, he had changed his address 6 times. The plaintiff served a writ of summons on his old address by inserting the writ in the letterbox. He claimed the plaintiff knew he had already moved out. If you were the master hearing the case, consider, well, do you think the judgment entered is regular or irregular? Changed his address 6 times. Right? So it's a fine line, isn't it? Well, is it the plaintiff's fault or is it the defendant's fault? There are times when, well, if you think about it, I guess the ultimate question is, well, does the defendant, or did the service bring the defendant into or notice that there is such a proceedings? Right? Ultimately, that's what service is for, correct? Right? It's to notify and serve the actual documents to the person, to the defendant. So if it is true that the defendants never got the documents and never been served properly, then perhaps it's still a irregular judgment. However, sometimes in such a case, if the defendant really has moved 6 times during the last year, the plaintiff would also make arguments. Perhaps, well, I'm going to argue that the defendant knew there's such a proceedings. It's just that he has been trying to evade service. Right? It's both sides may have a bit of argument. So depending which side sounds more credible to the judge. B, whether you will consider the merit of the defense. Well, depending what your answer to question A is. Right? Remember, if it's irregular judgment, you are the defendant can get the judgment set aside as of right, okay? Automatically entitled. Can the court attach conditions? The court can always have the discretion, okay? So it's very unlikely the court doesn't have discretion. So if you have to choose one, normally they have discretion. It's just less likely, right? Because it's been irregular. So on the other hand, if the court decided it's regular, then likely to attach conditions, right? And likely to consider the merit. Remember, it has to have merit in the case, which is real prospect of success. Okay. C, if you decide to set aside the judgment, whether you will attach any conditions and reasons for your decision, again, that depends on A and B and how strong the case is, right? You actually have to, if you decided it is regular judgment, you will have to look at the merit of the case, of the defense, then depending how strong the defense case is, you will then decide. So it flows through, right? It's like a detective novel. You have to follow the path. Depending which decision you make, you branch off. Okay. So, now straight after order 13 is order 14. Okay? Continuing on the spectrum. This is yet another way the plaintiff can knock out the case in favor of the plaintiff. Okay? In which case, just like the default judgment, if you obtain a summary judgment, it will cut short the whole process. It will conclude the case. Okay? Summary judgment is a plaintiff's application, if made. Just like default judgment, right? Just like application for judgment in default. Plaintiff's application. So the plaintiff's got a few applications or avenues to shortcut the whole process, right? Because we all know civil litigation is long, timely, costly, etc., etc., etc. So there are quite a few mechanisms. Now, what is summary judgment for? Now, remember I told you, did I tell you, or did I tell the other class? Sorry. Did I tell you about dishonor check? Anyone has experienced a bounce check? 彈票. No, never received a bounce check and never written one? Very good. Okay, let's choose my next victim. Doris, yes. Doris. Okay, so Candace. Doris and Candace. Ooh, D and C. Okay, so sorry, Doris, you're gonna be my defendant because D is just easier. Okay, so Candace delivered some goods to Doris. Doris wrote Candace a check. And that check, Doris didn't keep enough funds in the check account, so it bounced. Now, dishonor check is one of the easiest way the plaintiff can win. Because in the banking law and bills of exchange law, the proper wording is bills of exchange law, concerning checks, a check should be as good as cash. That's how our finance system runs. Part of our financial system is that bills of exchange must be good. Okay, otherwise everything can collapse, right? If you pay a check, it bounces. Although in real life, yes, we know sometimes it happens. Okay, but because a check should be as good as cash, as soon as Doris' check bounced when Candace tried to present it, right? Candace is the claimant or plaintiff, right? So Candace went to the bank to cash the cash or bank in the check. It bounced. She can straight away turn to Doris and sue her, right? Even if if you want, Doris may offer to pay you properly, right? But if not, you can sue her because of that legal principle. Check should be as good as cash. Now that's one very clear-cut case because Doris is in the wrong. Now what are summary judgments for? In fact, that is one of the most commonly used scenario for summary judgments. Okay, summary judgments are used for very clear-cut case where the defendant really has no argument to defend himself or herself. Okay. Again, it's a plaintiff's application to obtain judgment on the grounds Doris, the defendant, has no defense to the claim, and there is no complicated issues that should be tried or heard before the court. That's the whole rationale. Meant for clear-cut cases, unsuitable where there are substantial issues of fact in dispute. For that reason, the application for summary judgment is not available to some causes of action. Summary judgment, if obtained, is a legitimate judgment, just like default judgment, we just looked at under Order 13 and 19. So it's just like a final judgment as well. As I said, for certain causes of action that tends to be involving complicated facts, you cannot apply for summary judgment, such as libel. Libel and slander are two forms of defamation. 诽谤, 诽谤. Okay? One is just written. Libel is just a written form or permanent form, and slander is just words spoken. Okay, but they are both forms of defamation. Forced imprisonment, fraud. Because fraud tends to have a very high hurdle to prove. Okay, even though it's still a civil claim, it can still be a civil claim. It's harder to prove generally. Okay, and these are only some of the examples. Okay, so no summary judgment applications for this. The whole rationale is Candace or Doris, if your check bounced, it bounced. Full stop. Okay? No excuse for you. Because it should just be as good as cash. If it isn't, that's just your fault. The only thing you can have argument to defend like a bounce check or what we call dishonored check, is if there is total failure of consideration. For example, let's say Candace says, yes, Candace supplied you with, again, projectors. Okay, 1,000 projectors. And therefore you gave the check to Candace as payment. Unless you're saying, no, the whole thing is a fraud. No, you can't use fraud. So the whole thing was never delivered. So my check, I shouldn't give payment. It was what we call a total failure of consideration. Then you can defend your dishonored check. But there are only very, very few defenses you can raise for dishonored check. So it's a pretty clear case. Assuming Candace did deliver even if some of them are defective or there's a slight shortfall, etc., there's no defense to a bounce check. Okay, so it's very hard for you to defend. Now, why do we have summary judgments under Order 14? Well, if it's as simple as that, right, should be as good as gold. It's not, then it's your fault. Then, Candace can knock out the claim, right? Basically, is shorten the claim and be able to get judgment against you, the defendant, if the case is so clear-cut. Okay, dishonor check is, of course, only one example. Let's say you have a very simple loan agreement that has not been repaid. Right? That has not been repaid. Everything is very clear. Loan agreement, Candace lent Doris $1 million, 20% interest rate. Repayment time due, not repaid. Pretty straightforward, right? If there's no complications. If Doris doesn't have any defense that can come up with, she cannot come up with anything. She cannot raise any tribal issues. Then, we shouldn't stop, or Candace, the theory is that Candace should be entitled to obtain judgment earlier rather than fighting the whole case, because the whole case is so clear-cut, simple, and Doris has no defense. The whole rationale behind it. So shouldn't have to make Candace wait till the end and waste everybody's time and cost. Okay, so quick and economic mechanism for a plaintiff to obtain judgment against defendant where it's plain and obvious there's no defense to the claim. Now the Order 14 procedure is not meant to be a mini trial. If a lot of factual issues need to be raised, it's not suitable because it's not clear-cut enough. The court will not attempt to resolve issues of credibility. The court will not consider whether the defense is to be believed, but whether it is believable. Let me pause there. Okay, not meant to be a mini trial. If, let's say it's not a bounce check, again, one of those, goods delivered, but you're saying it's defective, so you raise quite a considerable counterclaim. Okay, you have a defense, you have a counterclaim. It's not so clear-cut anymore. If Candace saying, no, Doris' evidence is forged or she's lying, then you have what? You have issues of credibility, right? Which makes it, again, not so simple and clear-cut anymore. Okay. As to whether this, they like to use this a lot, consider whether the defense is to be believed, but whether it's believable. So the hurdle for the defendant to raise an arguable defense is very easy, as long as you have some substance and doesn't really sound like a space movie fiction, right? So the defense, not at this stage, is very early. When do you apply for this is any time after the defendant filed the AS. The defendant might not have even filed the defense. We see this a lot, for example, in money lenders, simple, straightforward loans, no defense. Most of the time, the moneylender would apply for Order 14 summary judgment after the defendant filed AS. Why do you wait till you file AS? We want to let the defendant say, are they contesting? Right? If the defendant in the AS saying, no, I'm not contesting, then you don't go through this. Right? Because the claim is already admitted. Yes? Right? So if the claim is admitted, you don't go through the whole deal to prove that they have no defense, right? Because it's easier if they admit it. Okay? Case concluded, just a matter of how to pay and when to get paid. Okay? The hurdle on the plaintiff side, the plaintiff has to show a very clear-cut no defense case. On the defendant side, it's very easy if they have any substance at all in their defense case, they'll be able to pass the hurdle to continue the case. Because If we're getting a summary judgment, we are saying, no, we don't even want to wait till they file the defense. Sometimes you can still apply after they file the defense if you think the defense is of no substance. Okay? But the hurdle, again, for the defendant side is low. Okay, it's easy. When I say the hurdle is low, it's easy for the defendant to persuade the court, yes, I have an arguable defense case, because the hurdle is not that high. The defense is to be believed, but not to consider whether the defense is to be believed, because that's already judging the case. It's like a mini trial. But if the defense case is capable to be believed, is it possible to be true, in other words? Okay, that's all. It's a very low hurdle. If there's no fair and reasonable probability of defendant having a real or bona fide, meaning genuine, defense, summary judgment will be granted. Ng Xiao Chun and Hong Chun San. By the way, let me remind you, your assignment will have summary judgment, so pay attention. Okay. Okay, so next. Tests, there are many tests. You can, but most of them are pretty similar. They are just worded in a different way. Okay. The test is whether there's a tribal issue that amounts to an arguable issue in law. If the answer is yes, summary judgment is not appropriate. The rationale is to prevent a defendant from delaying judgment where there is plainly no defense. That's the rationale behind Order 14 applications. It avoids the time and expense of a full trial because there's no point and no substance in the defense case anyway. We are saying under Order 14 mechanism, don't let the plaintiff wait. It's obvious Doris cannot defend her dishonored check case, right? There's nothing she can raise to counter the argument or the claim. So let Candace have her money. That's what we're saying, right? Order 14 summary judgment suitable where, now they like to use this term a lot, defendant's assertions are viewed as practically moonshine. It's like practically moonshine, you may say, what is that? Moonshine what? Practically moonshine is something so unbelievable that nobody's going to think it has any substance. Okay? Completely unbelievable. Science fiction movie, something out of outer space science fiction movie. Unbelievable. Okay, that's from Man Earn Limited and Wing Ting Fong. Where the defendant's case, or the defendant is arguing something that is seen as being, again, the wording, incredible or almost incredible. Just different way of phrasing it. If there real dispute of facts or where the factual matrix is unclear, summary judgment is not appropriate. Okay, so any questions so far? So you understand this mechanism, just like default judgment, is to shortcut the process, right? Make it shorter. Make the litigation end earlier. If the judgment is obtained in favor of the plaintiff, right? Okay, it's all plaintiff application. Discuss whether the judge should make an Order 14 application against M in the following scenario. J signed a contract with M for the supply of goods for $500,000 within 2 months. J paid a deposit of $100,000 to M in anticipation of the production work. M failed to deliver the goods after 3 months. So 2 months and 3 months, time expired, right, for delivery. Agree? J terminated the contract and asked for a refund of the deposit paid. When M refused to make the refund, J commenced action against M for refund of the 100,000 and additional damages. Is this something suitable for an Order 14 application for summary judgment? So you have a contract for supply of goods. Time limit for delivery was 2 months. 3 months has passed, no goods delivered. Deposit of 100,000 has been paid as deposit. J wants it back after terminating the contract. Do you think it's a clear-cut case? From the facts given, okay, assuming no further complication of facts. Who thinks yes? Suitable. You can raise your hands higher, it's okay. I would raise my hands too. I think it's okay. I think it's appropriate. It's pretty simple, right? Pretty simple contractual breach. I would say that's total failure of consideration. That's nothing delivered, right? And I just want the return of my money. Well, whether you use the cause of action of contractual breach or unjust enrichment, because I got nothing and I paid 100,000, it's pretty straightforward, I would say. So I would say it's appropriate. Now, of course, they're going to give you more scenarios. Apply the facts in case 1, except that J had told M before signing the contract that the price of materials would remain constant in the near future, but the cost spiked sharply after the contract was signed. It's likely that M would rely on that as a defense. J commenced action against M for refund and additional damages. What do you think? Appropriate or not appropriate? Well, what defense would M be relying on? It may be like a misrep, right? Sort of similar to a misrepresentation, right? So additional element, not so sure now. You probably will need more facts to consider whether it's clear-cut enough. For example, you know, in contract, right? You've studied contract law, so let's say if you have a written contract and all the terms are very clear, and if it contained an entire agreement clause, then you may shuffle away or waive away the misrep, right? Potentially. It depends whether it is really misrep or part of the terms, etc., right? But it certainly adds a little bit more complication. Agree? This one is, you need more facts to decide whether it's appropriate. Okay, but it's harder, certainly harder now. Yes? Case 3. Again, same facts, except that the goods have to be made and processed according to the requirements of J. It's an OEM arrangement. Okay? J gives the design. Okay? Before end of the 2 months, M wrote to J claiming that the manufacturing process required by J was so technical and inherently impossible to accomplish that it could not complete production of the goods within the time agreed. M claimed to need a further 3 months to be able to complete production. J commenced an action against M for refund of 10,000 and additional damages. So what we're saying is, well, they had an agreement, right? Initially, they have agreement. After the original agreement, M wrote to J saying, I can't do it. Is that correct? Pretty much. Yes, or I need more time or whatever. I can't do it within the time limit. Do you think this is a case for Order 14? Do you think, let me ask you, do you think case 3 is easier or do you think case 2 is easier? Well, 2, we have an allegation of potentially misrepresentation, right, as a defense. Here, what is M trying to do? Going back to your contract law now. Well, can be breached, but what was she trying to do when she wrote? No, but frustration has to be a lot more than that. Yes, it mentioned the word impossible, but it's not like a force majeure sort of frustration, isn't it? Not a natural event or not burned down or like that, right? So I think if I simplify, put it in a simplistic term, M was probably trying to get more time. Is that correct? So she was probably trying to vary the contract, potentially. Right, depends whether your argument is frustration, going to contract law now, but whether you're trying to argue frustration or whether you can simply say M was trying to vary the contract, but did J agree? Did J agree? Not really. So if I were J, I would simply argue, well, we had a contract. I did not agree to any variation. I would say this case is actually easier than the misrep scenario. Like to me, right? Unless, as you said, you're arguing frustration, okay? Then everything break loose, okay? But short of that, if we're saying this is a variation or attempt to vary the contract on M's part, and J didn't agree, so there's only still one original contract, still a breach by M, right? I would analyze it that way, but I don't know how, in your contract law, what else you would argue. But I would actually say this is easier than scenario 2. For scenario 2, if that's misrep, it really is factual and credibility issues. Okay? Here, M's argument is not really valid argument against a breach, because it's only her attempt to vary the contract. Case 4. Apply the facts in case 1, except that J's initial deposit was paid by way of check that was dishonored. Okay. Upon presentation, J was only able to honor the check after 1 month. J claimed that M had agreed to abide by the 2-month time period to supply the goods, notwithstanding the dishonored check in the beginning. But don't get confused, right? M didn't sue J for the dishonored check. So it's just that here, the scenario is simply that J paid the initial deposit late. Okay, so don't let it confuse you just because what I told you before. Okay, so J claimed that M agreed to abide by the original delivery period or time limit of 2 months. However, there was email from M claiming that M intended to keep the contract but will only start to make the goods upon full payment of the deposit. J commenced an action against M for the refund of deposit and additional damages. Clear cut or not? Is it a clear cut case? Well, we have 2 versions of story, right? J is saying J is alleging M agreed to abide by the original delivery date. M is saying, and it sounds like she has written proof. There's an email, right? There's an email here. There was an email from M claiming that she intends to keep the contract but will only start to make the goods. Now, because this gets more complicated, right? If J performed his part of paying the deposit on time, then he can say, okay, M cannot vary the delivery time. But because J himself did not perform entirely to the terms, well, then there's change of circumstance, right? And then whether you can insist M comply with the original delivery date. And J and M are telling different version of story, right? J is saying M promised to abide by the time. M is saying, I already told you I wouldn't abide by the time. I wouldn't start production until you pay me the deposit. I only count the time from then. So what do you have? Is it clear cut? There are, obviously, with 2, well, they're going to be witnesses for the case, probably. There are credibility issues. Who is telling the truth, right? There is substantive, factual disputes. not appropriate. Okay? So you get the gist of it, right? Substantive factual disputes, not appropriate. Complex factual issues, not appropriate. Credibility issues of witnesses, not appropriate. Okay? In other words, if the judge has to decide further and look further into the evidence. Okay? Prerequisites. Okay? Before, what has to be, what criteria has to be fulfilled? The writ and statement of claim have been properly served on defendant. Defendant has returned the AS within prescribed time limit, indicating an intention to defend. Now, pause there. Remember I said, beware of the timeline. Be awake, 心水清啲 about the timeline. If defendant returned the AS, okay, just to hound it into you, I'm hammering it into you. Defendant returned the AS indicating not intending to defend, what do you do? No, hang on. Returned indicating not contesting. It's not judgment in default. Okay. Form 16C, right? That process, right? Admission. Because if not intending to contest the claim, defendant is saying, yes, I have liability, yes, I will pay somehow, right? Assuming it's monetary. So do you go for summary judgment? No, not only because it doesn't comply with the rules, it doesn't make sense, right? In a summary judgment application, the plaintiff has to prove defense has no case at all. Forget about her. Don't let her defend. She has no, look at what she can say. She can say nothing that is substantive to defend the claim. Let me get the money now. It's a high hurdle to just say at such an early stage, before evidence is disclosed, before discovery, before she even filed the defense, to say that she has no case. I have a very high hurdle to jump. If defendant is admitting the claim, why would I bother? I get it automatically, pretty much. Right? So make sense of the rationale behind. Okay, so return AS not contesting the claim. You do not apply for a summary judgment because you get it anyway, right? You get your money sooner or later anyway. The case has been cut short anyway. Return the AS. What if not return the AS? Do you apply for summary judgment? Right? First of all, by the rules, you cannot. Right? Just looking, you are so good at the rules, you know, no AS, cannot have summary judgment. Apart from that, why not? What do you do? Order 13. Right? You go straight for Order 13 if they don't return the AS. Correct? Is doing Order 13 easier or Order 14? 13 is simply the defendant's failure to return something to the court. Right? No need to look into merits. In summary judgment, you have to look into the merits of the case, right? So of course you choose the easy path. Get it? Not only do you have to comply with the rules, it makes sense. Okay, the third point there is a must. The affidavit, guess what? How do you apply? You can tell me the perfect answer. You apply by summons and to a master, and it's going to be heard in, yes, perfect answer, everybody. Okay, so the affidavit or affirmation, which one is the religious one, by the way?
Affidavit.
Affidavit is a religious one, affirmation is the non-religious one. I don't think we're going to mark you off because you use one way or another. Okay, I normally use affirmation. It's the more neutral one. It doesn't matter. Okay, we're not going to take marks off as long as you use one of those. Okay, but just get used to using affirmation if you can. Okay, if you have to, because it's more neutral. The affirmation in support of your application by summons is valid and not defective. You have a few criteria. One of the most important thing is that you must include the deponent. The deponent is the person that has affirmed or that is making the affirmation. The person making the affirmation can be called two ways. It can be called either a person making the affirmation. Do I have time? You're going to spell using that. Is either called the deponent nant, yes, or you can call it affirmant, AFFIRMANT. Okay, deponent or affirmant means the same thing here. It must include the deponent's belief that there is no defense to the claim. That is one very important sentence. If you do not have that, your affirmation is defective. Okay? There are bits and other, a little bit other bits and pieces, but this is the one that we want you to believe, to remember. There was one time I was instructed to appeal on an Order 13 on urgent instructions, and I looked at it over the weekend. This sentence is missing in the affirmation. I ended up having to, of course, ring everybody during the weekend, and because it was the hearing was first thing on Monday morning, I think around 10, I had to we can't do it at the firm and file it in time. So we actually did it at the court. At court and at the Oaks office at the court. Just handwritten to supplement this affirmation. So it would collapse. Okay, if your affirmation doesn't have this sort of sentence to this effect. Okay, so that's the bit we want you to remember, although there are other bits and pieces. Timing, no time limit as to when to make the Order 14 application. But generally ASAP after the prerequisites are met. Because that's the whole purpose of Order 14, right? Is for the plaintiff. The plaintiff wants the money ASAP. Okay, although you can have summary judgment for other reliefs, mostly it's money. In most cases, it's money. Again, this is everything that you have already told me about. Inter partes summons, so both parties before the court, supported by affirmation. The affirmation must verify the facts on which the claim is based and state that in the affirmant's belief there is no defense to the claim or part of the claim. Normally we say the two key phrases. Okay, is in the affirmance or the affirmant verily believes that there is no defense to the claim and there are no tribal issues. We normally be very safe and state both. Okay, no defense and no tribal issues. The affirmation may contain a statement of information and belief as long as the sources of the information and the grounds of the belief are also stated. Because remember, at that point in time, did I tell you the difference? Did I tell you the difference between witness statements and affirmations? No, not yet. Have you heard of witness statements? You have heard of witness statements, right? Apart from the flow chart. I've seen PCLL students still get confused about what's the difference between affirmation. Affirmation are for interlocutory. So Okay, so that's all. For all interlocutory proceedings, why do we have affirmations? Okay, affirmations are for evidence. Basically, both of them are evidence. Witness statements or affirmations. Affirmations are evidence to support your interlocutory applications. And remember, you have numerous during the lifespan before trial, right? So why do you always hear affirmation to support applications? Witness statements are for the purpose of the main trial. Okay? Just for you to have the concept, you're not really getting examined on witness statements, but so that you understand. So remember summons and affirmation, right? Summons is that document you call the other party and you are requesting a hearing before the court. So the official, I would almost say that is the official application document. And affirmation, why do you always have to? You heard we use the word supported, because that's evidence, right? So you hear summons, supported, because application supported by evidence. Okay, so the affirmation, the last point there, the affirmation should be made by the actual parties themselves. So if you're the plaintiff, if you're a natural person sort of litigant, and not a company, you should affirm your own affirmation rather than get the solicitors to. The only circumstances where you would get your solicitors to is if you're overseas, or if for some reason you can't. There must be some reason. Okay, you're not in the jurisdiction and you need to file the evidence, and your solicitor verify for you. But that's not the most ideal. If you're a corporation, then a director, normally. And the director needs to have authorization from the company. Now, so yes, application procedure again, summons affirmation, okay, we know all that. So what happens after the affirmation is filed? Okay, you make the summons affirmation, then what? Now, once the plaintiff complies with all the requirements and serve everything properly, the burden shifts to the defendant. Okay, we've stated we believe you have no defense, no tribal issues. I've shown proof that I've served the SOC on you, etc. The burden shifts to Doris, the defendant, to show that there's an issue that ought to be tried, or there is some other reason why the case should go to full trial. Okay, we've stated our case. Your turn now to tell us why not. Okay, defendant's turn. Remember, it's the plaintiff's application, right? So the defendant has to respond. Hearing. The summons and affirmation must be served on the defendant at least 10 clear days before the hearing. Okay? The first hearing date is called the return date. Now, okay, just to be sure, yes, 10 clear days. In the exam, you can just write 10 clear days, we'll accept that. For your own understanding, 10 clear days means full day, like 24 hours. You count the full 24 hours. So let's say if I say 3 clear days. Okay, if I have a hearing next Friday, and I need to file or lodge my submissions 3 clear days before that. If my hearing on Friday is 10 a.m., I need to lodge Tuesday morning at 10. Okay, 3 times 24 hours, 3 full days. Okay, Tuesday whole day from 10 to Wednesday 10, Wednesday to Thursday, Thursday to Friday. So 3 full days. Okay, that's all it means, clear days. Defendant can file an affirmation in opposition, and they normally do. Okay, because the defendant doesn't want to be knocked out of the litigation, right? They want their chance. No oral testimony is permitted, no witnesses allowed. Now the easy way, I'm going to tell you how to remember no oral testimony permitted, no witnesses allowed. Most interlocutory applications, no oral testimony. Okay, you can remember that simple rule. Okay? If you actually need or wish to, for some reason, to adduce oral testimony, it's very hard. You need to get leave of the court, and it's very rare. That's what your affirmation is for. Like, that's your evidence. Remember I said the first time you come back to hear the summons before the master is called a return date. This term here. Okay, return date. Oh my goodness, I'm overdue to you guys for a break. Do you want a break now? I think let's have a break now. We're overdue for a break. Sorry about that. Okay, so let's have a break now before we come back about the